Today we're going to talk to you about advisements, arraignments, and criminal protection orders. To help demonstrate the importance of these hearings, we've invited friends from the Denver bench, the prosecution, and the defense bar. Viewer discretion is advised. Under Rule 5, a person under arrest shall be taken without unnecessary delay before the nearest available county or district court.
All right, the court will call Roper Lakesmith. This is 17 CR 12345. Good morning, Mr. Lakesmith, or Mr. Roper. I can call you Roper. I know you well enough now.
Hey,
How
Judge.
are you doing?
Can I get a Tom Collins?
How are you doing today?
I would tell you how I'm doing. I'm terrible.
What's going on?
I'm
Mr.
here because the
Roper?
police are professional liologists. I'll tell you what happened. Here's what happened. I was just sitting there minding my own business, doing my work, and this guy came by, and he's a big guy, and he had a scar on his face, and he was like, "Hey, man, put this in your pocket for me real quick." I was like, "Whoa, dude, what's all this about?" And
You
he was
know,
like,
Mr. Roper, I've told you this before. You have a right to remain silent. You always forget to exercise it. Everything you're saying can be used against you.
Whoa, slow down, Cookie Jarvis. Can't you just fax this to my lawyer?
Under Rule 5, it is the duty of the court to inform the defendant of his right to remain silent, right to counsel, voluntariness of plea at arraignment, right to bail, nature of charges, right to jury trial, and right to demand preliminary hearing.
Mr. Dudorf, you want to go ahead and enter your appearance for the record?
Yes, Your Honor. Good morning. Catherine Dudorf on behalf of Mr. Roper Lakesmith.
Okay, Mr. Lakesmith is here today on charges of aggravated robbery. Mr. Lakesmith, you have not been charged yet. This is an investigative hold through the police department. The district attorney office has 72 hours to make a charging decision. If a charging decision is not made in that time frame, then you will be released on a personal recognizance bond. If you are charged with a felony, you'll be seen for second advisement, and at your second advisement, you'll be advised of the charges against you. Your bond may change up or down depending on whether or not the charge varies significantly from the offense for which you're under investigation. Additionally, you have certain rights, and I'm going to go over those now. This is a state offense. You do have a right to a jury trial. You also have a right to a lawyer. If you cannot afford a lawyer, one will be appointed for you and available to you through the state public defender's office. You have a right to remain silent. Anything you say and everything you do in here is recorded, and it can be used against you, so you want to exercise that right to remain silent. If you do get charged with a felony, you may have a right to a preliminary hearing. Generally speaking, you have a right to a preliminary hearing if you remain in custody, regardless of the level of felony. You also will have a right to that preliminary hearing if the charges are crimes of violence or high-level felony and you're out on bond. You still have to file a motion in writing within 7 days of the date that charges are filed against you in order to reserve your right to that hearing. After that part of the process completes, you'll be arraigned in front of a district court judge. That'll be your trial court judge, and at your arraignment, you will have an opportunity to plead guilty or to plead not guilty. That's a decision you have to make for yourself, free of duress, coercion, or promises, and free of any medication or other substance that might impair your ability to make such an important decision on your own behalf. You have a right to bond. That's something in front of me today that I will be setting. Based on the pretrial report and the nature of the offense, I will be setting your bond at $50,000 cash, property, or surety with a GPS unit to be attached to your ankle as a condition of your bond. Bond is reserved for argument and can be argued on the next court date. Good luck to you, Mr. Lakesmith. Okay, the court will call Roper Lakesmith. This is 17 CR 1235 for the purposes of setting his bond. Okay, Mr. Lakesmith today is here on a motor vehicle theft. Counsel, would you like to be heard on bond?
Your Honor, I really would. You know what? Mr. Lakesmith is just the nicest guy.
He is really nice. I see him every week. I always like to see him in court.
He's one of our favorites. We all just love Mr. Lakesmith. And you know what? Today, he's not feeling very well today.
Oh, I can see that.
And you know, I just don't think it'd be good for him to have to stay in jail in his current condition. He's got a fever, he's sweating, he's coughing a lot, he's doing a lot of coughing. You know, I know he never comes back to court ever, but if we could just give him a PR bond today, just throw him a bone on this one. He's just really not feeling great.
You know, Your client is a CPAT Category 4 on my pretrial report. He has 5 active warrants for the same offense out of multiple jurisdictions. He has no job. He lacks all ties to the community, except for his warrants. And it looks like he's facing mandatory Department of Corrections because he's a habitual offender. But you're right. I mean, he just is so nice. He's so nice. And, you know, I can tell you're sick this time, Roper. You're really sick. And I'm a mom. I mean, I feel really bad for you. If nobody's sick should be sleeping in jail. So I'm just, you know what? Forget the report. I'm going to release you.
In setting bond, a risk assessment tool, if available, is helpful and should be given weight. In determining the type of bond and conditions of release, if practicable and available in the jurisdiction, the court shall use an empirically developed risk assessment instrument designed to improve pretrial release decisions by providing to the court information that classifies a person in custody based upon predicted level of risk of pretrial failure.
Okay, Mr. Dorf, would you like to be heard on bond? Mr. Lakesmith is here today on a motor vehicle theft, which is a Class 5 felony.
Yes, Your Honor. Thank you so much. First, I'll start with his CPAT score. I understand he's a CPAT Category 4, but a lot of things have changed in his life recently. He is employed. He recently got married, moved in with his fiance, who is also employed. He has been living in the state of Colorado his entire life, so he has some ties to the community. He's frankly in a much different spot than he was previously. So, Your Honor, given all that information, we'd be asking for a PR bond today.
Okay. Well, the court's going to respectfully decline that request. He is a CPAT Category 4. He does have 5 active warrants for the same offense out of multiple jurisdictions. He's, at least based on the pretrial report, it doesn't look like he's currently working. He lacks ties to the community, and it looks like the potential sentence is potentially a Department of Corrections sentence. So I am going to respectfully deny it. Bond will be set at $5,000 cash, property assured. Good luck to you, Mr. Lakesmith.
When considering conditions of bond, we should also talk about protection orders.
Okay, the court will call Roper Lakesmith. This is 17 CR 12345 for the purposes of protection order. And so, Mr. Lakesmith, it looks like there's going to be a protection order in this case. Looks like you went over it. Is there anything else that the court really needs to do about this?
No, Your Honor, I've fully advised Mr. Lakesmith of his protection order. We'll waive any further advisement.
I appreciate that because I'm really hungry and I need to get to lunch.
Under 16.4.1054, an additional condition of every bond in cases involving domestic violence, as defined in Section 18.6.800.31, in cases of stalking under Section 18.3.602, or in cases involving unlawful sexual behavior, as defined in Section 16.22.1029, is that the released person acknowledges the protection order as provided in Section 18.1.1001.5. Under 18.1.1001, protection order against a defendant, at the time of arraignment or first appearance, the court shall inform the defendant of the protection order. The trial court shall maintain jurisdiction to enforce, modify, or dismiss the protection order until final disposition of the case.
Okay, the court is going to call Roper Lakesmith. This is 17 CR 12345 for the purposes of protection order. And counsel, you want to enter your appearance?
Catherine Dudorf on behalf of Mr. Lakesmith. And Your Honor, I have fully advised him of this protection order. We'll waive any further advisement.
Okay. Well, I'm going to go ahead and go over it in open court so that Mr. Lakesmith is fully informed of the conditions of the protection order. So Mr. Lakesmith, Sarah Bailey is the protected party on this protection order. You cannot harass, molest, intimidate, retaliate against, tamper with, or threaten her. You have to vacate her home, stay away from her home, stay away from any other place she might be, which means you need to make an affirmative effort to avoid her. You can't have any contact with her directly or indirectly. You can't possess, purchase, or control a firearm or other weapon or any ammunition. If you have any of those items by law, they have to be relinquished, and we'll give you paperwork explaining how you relinquish those. You can't possess or consume any alcohol or controlled substance, Mr. Lakesmith, while the order is in place, and you do have to remain 100 yards away from Miss Bailey. Do you understand that, sir?
I do.
All right, good luck to you.
Under 24.4.1, 302.5, rights afforded to victims. In order to preserve and protect a victim's rights to justice and due process, each victim of a crime has the following rights: the right to be informed of and present for all critical stages of the criminal justice process, the right to be heard. We apply these statutory requirements when we consider protection orders. If a victim is present in a court at advisement or arraignment, we allow the victim to be heard in open court regarding bond and the conditions imposed on the protection order. After considering the alleged facts, the pretrial report, the defendant's history or lack thereof, and the victim's representations regarding safety, we then make decisions regarding the protection order restrictions. We also make sure the victim and defendant understand that the protection order may be modified later by the trial court if the issue is raised in court. Finally, we will discuss Rule 11 advisements at arraignment.
Okay, the court's going to call Roper Lakesmith. This is 17 CR 12345. Okay, looks like Mr. Lakesmith is on the docket today, charged with third-degree assault and also child abuse. How would your client like to proceed?
Your Honor, at this time, Mr. Lakesmith would like to enter a guilty plea to the third-degree assault charge. The child abuse charge will be dismissed pursuant to a plea agreement you should have in front of you. I have fully advised Mr. Lakesmith will waive any further advisement and the underlying factual basis.
No, that's great. I just really like it when you guys do this, when you just waive everything, because it makes my life so much easier and everything runs smoother with the docket. It's fast, it's efficient. So how do you want to plead, Mr. Lakesmith?
So I can just plead guilty and get out of here?
That's all you got to do.
Rule 11. The court shall not accept a plea of guilty or nolo contendere without first determining that the defendant has been advised of all the rights set forth in Rule 5A.2, and also determining 1. That the defendant understands the nature of the charge and the elements of the offense to which he is pleading and the effect of his plea. 2. That the plea is voluntary. 3. That he understands his right to trial by jury. 4. That he understands the nature of the charge and the elements of the offense and the effect of his plea. 5. That there is a factual basis.
Okay, the court calls Roper Lakesmith. This is 17 CR 12345. Okay, it looks like Mr. Lakesmith is charged with third-degree assault and child abuse. How would your client like to proceed?
Your Honor, there is a proposed plea agreement in front of you today. Mr. Lakesmith would like to enter a plea of guilty to the third-degree assault charge. The child abuse charge would be dismissed as part of that agreement. We will waive any formal reading and advisement on the charges. He's been fully advised, and we'll also waive the underlying factual basis.
Okay. Mr. Lakesmith, it looks like you went over some paperwork. You've signed and initialed in this paperwork in a couple places. You did this along with the assistance of your lawyer. Is that correct?
Yes.
What this indicates to this court, Mr. Lakesmith, is that, first of all, you understand what it is you're pleading guilty to, which is third-degree assault. Is that correct?
Sure.
It also indicates to the court that you understand the possible penalties you face when you enter into this kind of guilty plea. Is that correct?
Right.
Finally, it indicates that you understand all the rights you have and the rights you give up when you plead guilty. Is that correct, sir?
Yes.
Are you doing this of your own free will?
I am.
Are you under the influence of anything right now?
Not right now.
And that's good. And have you had enough time to speak to your lawyer about this decision?
I have.
How would you like to plead on the third-degree assault charge, sir? Guilty or not guilty?
Guilty.
I accept your guilty plea is knowingly, voluntarily, and intelligently entered into. Conviction will enter and we'll set this for sentencing. Thank you.